So our next session will be Mark, and this will be a great session for our students who are thinking of a kind of a longer term academic career, looking at research. And Mark has extensive experience in this area of doing research and also a kind of across disciplines, right, Mark, into your other area of love. So,
Sure. So, not only criminal law and law generally, but Asian studies and also um, psychology, of course. So that's
that's
what I'll talk about a bit today. I've got half an hour with you. Um, I'm on beautiful Biripi country here as well, Becky, and others. So Guruk in the local Tongue language, and this is where I do spend some mornings on Lighthouse Beach with Coco the Labradoodle. So I do acknowledge Uncle Bill, Auntie Rhonda, and others in the Biripi Nation that are really closely supporting Charles Sturt in a way that we see our Wiradjuri Bathurst Space Elders doing as well. And uh, having done that acknowledgement, I'm going to swap from focused on the rich experience I've had in country, on country with elders in Australia to think about the international exposure that has shaped some of my legal scholarship and my academic work, and what I think is really important law reform in not only those countries, but how it makes me think about law reform requirements in Australia. So there's a bunch of people on this slide that I'm going to acknowledge and acknowledge their legal cultures and their comparative perspectives. And they're the giants on whose shoulders I've been standing when I've done a number of different research projects that are related to criminal law and criminal justice reforms. So in the language that Professor Kent Anderson speaks fluently as an American, Ibuski Sensei, Professor Makoto Ibuski, and also one of my PhD students, Carol Lawson, who fluent Japanese speaker and Japanese law translator, coming to do a PhD with me on the role of civilian overseers within prisons. I have just learned so much about the Japanese legal system that makes me think about the Australian legal system. So, as it says there in Japanese, domo arigato gozaimasu, to those people who have opened my eyes to what happens in a law reform process I'm going to talk about in a moment. But Carol's PhD, which you can read in full if you want to, at that link, was all about when do we have civilian oversight officers working within the ACT Canberra prison, and how would that be as a model compared to what Japan spent a lot of time doing to get a particular model in Japan, rather than using social workers, people who'd been working in and around prisons to do that sort of work in Japan. They had a whole bunch of academics and administrators and bureaucrats coming to do official visitor work, responding to questions that prisoners were asking about their treatment. And it was just not a very similar system to what I was familiar with in New South Wales prisons and in ACT, for example. But again, without doing this type of work and going outside of Australia to think about that, inspired by colleagues' work and also students' work, I would not have really even thought that there was a different option for an official visitor scheme in prisons. I did spend some time on a DFAT funded trip to Myanmar. So Chizu Timbare to those people at the University of Yangon who had me for at least a week during the wet season, as it turned out. I had to use a microphone to get over the sound of the rain on the roof. It was just so deafening. As I was speaking to students learning about their Burmese legal system in fluent English, with fluent bilingual, trilingual academics teaching law in law school. Every single academic except for one was a woman in University of Yangon. It's a public service Department of Education style gig where you can get transferred from one university to another like a public servant. The only male I met there was someone who was working in the library. Because of the history of law in Myanmar, there were some really amazing military lawyers working as academics in that jurisdiction. But their real passion often was human rights law, but they were working under a military junta for a lot of their careers, and for a lot of their careers, it was illegal to teach law in law schools in Myanmar. But as you'll see in a moment, that overlapped with some of the other scholarship that I was doing in and teaching I was doing of the ADF in military law as well. So a big Kopkun Mark Club to the exposure that I've had to Thailand for all sorts of reasons, including working at Chulalongkorn University for 7 months, being a adjunct at Chulalongkorn and also at Thammasat University, and having 2 really interesting PhD students have taught me a lot. So Dr. Apachon Chandrasen now works in the Council of State. It's like the Attorney General's Department in Thailand. And he did a comparative research project on what he can learn about anti-fraud security law in Thailand from looking at not only Australian law, but theories of regulation that Professor John Braithwaite and colleagues had established as theoretical perspectives on regulation from ANU. Then a woman who grew up in regional Victoria, Dr. Sarah Bishop, and went on an exchange to Thailand at age 14. By the time I met her, she was a fluent Thai speaker who could read constitutional law decisions in Thai language, spent a lot of time in country looking into what constitutional rights histories in Thailand had been, and whether the non-Thai speaking Western academics really understand what's happening with the culture of human rights in Thailand. And she now works at National University of Singapore. Just fantastic exposure there for me as a person who enjoys comparative legal research and law reform and policy. The latest PhD student of mine who has submitted was Wing Commander Joshua Liddy, who's a foremost military lawyer working in the Air Force, and he himself has done a lot of traveling around, working as a military lawyer in the Pentagon, working in the military legal system in Australia, being deployed on active service as an advisor to all sorts of folks on front lines of conflicts as well. You can see how when I went to University of Yangon, I was starting to understand the relevance of military law for civilian lawyers. But in Australia, it's all about misbehaving ADF members, isn't it? But at University of Yangon and in Thailand, the military law had been used against protesting civilian students in law schools. And that separation between military law and civil law at times of a perceived emergency was really just being relaxed a little bit. So thank you to all of these people. Let me go to the Japanese ideas around law reform to start with. My main theme here is that when you're starting to think about doing legal research, doing legal practice, but also doing law reform across national and international boundaries, I think you can compare apples and oranges, and you should. You absolutely should, to get a perspective of what's wrong with our Anglo-American criminal justice system that we practice in Australia. To what extent is that a model that we possibly are just trying to tame as like a snowball? It's becoming bigger and better, sometimes worse, as it evolves from those perspectives. But what does it really mean for us as researchers to challenge ourselves and to go somewhere different and to understand a different legal system altogether? So I just picked something off my library shelf. The Asian Journal of Comparative Law is a great journal where you have people from all different jurisdictions doing comparative research of jurisdictions that are similar to their legal system, but then also quite different. So just for an example here is someone as a legal researcher who's comparing merger regulation law in Australia with merger regulation in China. Um, very different political systems, very different commercial law systems, very different corporate law systems, very different understandings of power and commerce in those countries. And the very title, and if you read the paper, suggests that we can do these comparisons, and these comparisons are useful. And at the end of the day, yes, Australia might appear to be ahead of China with the ACCC and all sorts of work, but she found the Chinese jurisdiction to have a clearer understanding of how they would assess particular parts of regulation behaviour than even the ACCC was doing. And did the ACCC have a really good understanding of the methodologies that would be needed for various reports in this regulated process? Well, not so much as China was the outcome here. So I think we should really do that comparison of apples and oranges. And in a national context, as a criminal lawyer, that's what you see when you compare ACT codified criminal law, ACT common law from the ACT Crimes Act, with Victorian common law, with the Commonwealth Criminal Code, which is different to the Griffith Code in the Queensland jurisdiction. So, as a lawyer, an academic in Australia working with criminal law, it can feel as foreign sometimes going to a different legal system to understand what is the history, the genesis of the legal principles. And sometimes I felt that going to some parts of Southeast Asia and Asia a little bit more familiar at times than what it would sometimes feel like to go to Queensland to understand the history of criminal law. So I think we shouldn't underestimate the fact that within our federation, we have quite a lot of differences that you must manage. And it's the core legal skills, as we've heard today, that really set you up for being flexible as not only a legal practitioner, but a legal researcher and a law reformer. Just back to Carol's PhD, when Japan started to think about how to do civil oversight within Japanese prisons, and she gave questionnaires to every single exiting prisoner who was exiting Japanese prisons in a period, and was comparing that to the views of people incarcerated in the ACT Alexander McConaughey Centre, the prison in Canberra, to get a sense of how they thought civilian oversight was working in those two jurisdictions. But, really initial starts for her were thinking about, well, what's happened in the UK, Germany, Japan, and Australia. And there were really good early comparative studies of that to get a sense of what is the way in which the Nelson Mandela rules, other like the Bangkok rules, the rules that govern the treatment of women in prison from the UN's perspective. How do all of those types of different jurisdictions and also international law shape the way in which we should think about law reform in a particular jurisdiction? So let me tell you about a project that was really just revealing for me as someone interested in Australian law reform. I'm going to talk, I feel really old when I talk about this, but it's work that I did sort of mid-career, possibly, you could say, in October 2004, which was 5 years before reforms were rolled out in Japan. And this was because in Japan, we had in 1923 abolished civilian jury trials like we know of in Australia. So rather than impaneling 12 citizen jurors to sit in a criminal jury in Japan, they abolished that altogether. And they didn't have a jury much at all, save for the prefecture of Okinawa, where they actually had an Anglo-American jury still operating pre and post World War II. So yes, together with colleagues, we were trying to get into that archive to compare it to this law reform process. The Japanese thought that it would be a really good idea if they looked at administrative law, criminal law, other forms of civil law, to start to think about whether Japanese people were too passive, and letting their legal system run all over the top of them and the government run all over the top of them? Should administrative law be strengthened? Should we have lay participation in criminal justice in Japan? And compare this law reform process I'm about to explain to what happens in Australia. They decided to reintroduce a jury, but it's going to be different. We would have citizens sitting alongside judges, so that there would be collective judicial decision making, with, say, 3 judges and 6 citizens. And they called this the Saiban-in system, Seido reforms. Saiban means court, and in is sort of an abbreviation of the word for person, nin. So Saiban-in is a citizen juror, or a citizen judge is a better way of saying it, a citizen member of a court. And when we were visiting Ministry of Justice in Japan, they would talk about, oh, we've got to have a hearts and minds process here. Watashi no shiten, watashi no kankaku, watashi no kotoba de sanka shimasu. I will participate through my own observations, my own perceptions, my own words. Confident, excited citizen there depicted wanting to do this type of research. The Ministry of Justice was so focused on getting the ads right, get the logo right, all that kanji, those Japanese characters mean Saiban-in Seido, but we want a good logo. Citizens coming together with judges to sit in criminal process. Let's write a haiku about all of this, so that there can be sort of catchphrases there and beautiful Japanese calligraphy. And when my fellow researchers and I and barristers in Japan were saying, well, what's your law going to look like? What's the procedure going to look like? Have you thought about this? Have you thought about that? Sometimes they had not. But the best thing about this process was that they took 5 years to do it all, to draft the laws, to draft the delegated legislation, to do empirical mock trial research, social psychological research, to understand how contemporary judges and contemporary citizens were going to cope under this law reform. Compared to our law reform processes, it just showed it up as being completely inadequate in Australia. When do we ever have a 5-year turnaround period to implement a criminal justice procedure, which is fully supported by academic practitioner input into the evidence base for what could possibly be the unintended consequences of that law reform? So, it was revealing for all of that reason. So this Mogu Saiban, the way in which you have a mock trial evidence base, I thought was just really different. Really intriguing in those 5 years when they did that, they found out that the judges were scared of the system more than the citizens were. How were we as judges going to explain what the law was, so that the citizens then could apply the law to the facts? Well, that's what we do in Anglo-American juries. That's what we should be good at doing in Australian contexts as judicial officers. But this absolutely petrified the judicial officers in Japan, and some of the mock trial work was exposing that. Some of the support work with the judges was exposing that. We tried to get some research funding, which we never did get, about thinking through systems in Australia that have lawyers sitting alongside citizens to make decisions. And we tried to get funding to say what's happened here in Japan and the decades since then is a really good barometer for how we could be reforming the administrative tribunal system in Australia, because the mental health review tribunals, the social security review tribunals can be comprised of citizens and professionals and some legally trained people, but not always. So what we saw as the dynamics here in Japan was a good foil to understanding the dynamics between legally trained decision makers and non-legally trained decision makers in administrative tribunals in Japan. Really interesting, but we never were funded for it. It was great to see the way in which barristers, the Japanese Federation of Bar Associations, was trying to get their head around all of this. And they were the people asking questions about defendant rights and complainant rights. not so much some of the law reformers. I just put all of these here. I can go back and have a look at it, perhaps. But here is Chief Justice Spiegelman of the New South Wales Supreme Court musing that lay participation in criminal justice would be a good idea, consulting with citizens who have been on a jury about which sentence they think would be fair, not to make it into an American system where sometimes the jurors do sentence, but why not have a thought here? But there's some nice quotes in there about, I suppose we'd have to have some sort of informed law reform commission reference before we made this decision. But as I said before, streets behind the process that the Japanese did have. I was involved in some other research, it included Japanese researchers and American researchers who were collecting empirical data on whether being on a jury in America or in Japan, the new system, whether that actually improved your attitude towards legal institutions and made everyone more confident in justice. So it was interesting there, and I've mentioned some of this. Just a final bit of advice, I suppose, if you start to get involved in this type of work and research and practice as a law reformer, as a practitioner law reformer who needs to look at different jurisdictions. There's just some great examples of not being culturally chauvinistic, of not being overly proud and reifying the American or the Australian legal systems, but just understanding the dynamics that might be generalizable, and really good advice for law reform in, say, Australia. And you can see here, this book on juries includes Sri Lankan, Marshall Islands, Brazilian jury research just as much as it has research from common law countries otherwise. Some of my exposure in Japan and then Thailand has shown me that we should just not turn our minds off using Southeast Asia, for example, as a basis of law reform. But we should also understand that in Thai criminal law areas, but also in the LLB completely in the two leading universities in Thailand, they teach Thai law in English as a bachelor's degree and as a LLM in a master's degree. You can do it in Thai language or you can do it completely in English. You can learn about the Thai system in English, mainly for Thai or half Thai kids who are not strong in Thai, but also for a whole range of expatriate legal practitioners as well. So, there are countries around the world with bilingual, trilingual legal academic staff who can deliver the entire LLB in their non-native tongue, in English. And there are textbooks written in English about the criminal law system in Thailand, for example. So much of legal research can be wrong when it's all based on monolingual English resources that are not written by bilingual and trilingual academics. Running out of time, but just another salient reminder was when I would host researchers from the Japanese courts, but also the National Police Agency at ANU when I worked there. And I can remember everyone saying to me, "Oh yeah, restorative justice in Australia, police conferencing circles, that's all a Japanese idea that's alive and well, and we've taken it directly from Japan and we've put it into Australia, and that's where the idea has come from." Many academics have suggested that. Many Japanese people scratched their heads, including one National Police Agency researcher writing about restorative justice for 12 months at ANU. He said, "I've never seen this happen. I've never seen police do restorative justice conferencing in Japan, but everyone that I read tells me it's a Japanese idea." So there's plenty of problems with cross-cultural legal scholarship. And, these are just a good reminder for us that you have to talk to the lawyers in country. So my final thoughts here, and I'll give us about 4 minutes for questions, but being parochial as a lawyer, a law reformer, and a legal academic is your worst enemy. And, we want to read reflections about legal systems in academia written by bilingual, trilingual, native academics and practitioners. And there is English language material that is getting to a level of educating us all, and we need to look for that and not to look for scholarship by people who have never lived in, been born in, or been impacted by the legal system that they're commenting on. And be a respectful tourist, as I'm saying here, immigrant and reflective learner when you engage in any comparative legal research. And as I said before, our system is not the best in the world. Other systems from developing countries, even if you want to call them that, are not the worst systems in the world. But talking between those two systems is what we need to do. Okay, I'll draw a breath there and see if anyone's got a question or two.
Maybe just a comment, Mark, and not a question, but my home country, South Africa, we also obviously if influenced by the English system. So our court system, looks very much like the English system. But interestingly, juries were abolished in 1969 with the Juries
Mm-hmm.
Abolishment Act, and the reason behind it was that there was some criticism from the judiciary and lawyers about the way that juries were biased in a racially divided country. So
Yeah,
it
sure.
was felt that the juries couldn't be trusted to not be biased, especially where you had different races in the victim box and the accused box. It was clear that there was bias, and so just something to think about in terms of the jury system, where you start getting a multicultural society.
Yeah,
And
absolutely. And a really important set of questions, because constitutional representative juries from the American perspective, very different to anything about representation and representativeness that we have within our own system and we tolerate. So, First Nations researcher Kate Aughty done fantastic work on the prejudice within the Australian jury system, whether it be at the point of challenge or the point of the deliberations that we don't really monitor and don't really know too much about. So when we lock away our juries and let them decide without telling us what they decide and without reporting, unless there's a problem, what the dynamics were in that jury room discussion, how different is that to actually having a fairly much on the record discussion between a Saiban jury, which is 3 citizens, 3 judges. 6 citizens, 3 judges often in sexual assault trials or whatever. And just to say one more thing about Japan, a lot of the people that come through the Japanese courts for serious sex trafficking and sexual assault matters that are transnational are foreigners being involved in sex trafficking. And, I've been sitting in court and seeing cases where the defense lawyers are asleep during the the prosecution because of the way in which there are biases against adequate defense for those quite serious matters against foreigners. So that is alive and well in the new Japanese system. The citizen jurors are actually sentencing for serious sexual assaults much more harshly than they ever saw in a judge alone trial, for example. And all of those dynamics you mentioned are useful. Sorry, Becky, you've had your hand up too.
It wasn't a question, it was a comment. But I did a comparative law unit through Charles Sturt, where we went to Dongguk University.
Yeah, in Korea. Yeah.
Just to say that experience, and it was only 3 weeks, but it was it really does open your eyes to cultures that are different to yours and how differently they do things and how much room for improvement we have here.
Yeah,
so yeah, it's just,
last time we offered that, we didn't get enough people to go. So
it was
uh,
amazing. If
of
anyone's
course,
ever thinking about it, do it. It doesn't matter where, just go.
of course, Korea adopted a new jury system as well in the wake of the Japanese reform. So it's a live issue for them as well. Might be a time for us to shift to our last presenter before we have the Albalinea session. So I'm looking on my screen, and thank you for listening to me. Looking on my screen to see whether we have Julia Ross here yet.
I'm here, Mark. Can you hear me?
Oh, yes, I can hear you. Yep.
Awesome.
Feel free to. Oh, there you are. Hello.
Hello.
Hello. Dwayne, I had talked to Julia about a set of questions that we might ask her. I'm just going to stop my recording and then start yours, Julia.
Thank you.